Brandon Castiglione is not guilty. The police jumped to conclusions. Within 2 minutes of the first officer arriving on the scene, Brandon was in handcuffs in the back of a police car. And because the police jumped to that conclusion, they did not do a thorough investigation. And as you've heard, they only looked for evidence that pointed at Brandon. I want to talk to you about some of the ways the police did not do a thorough investigation. Evidence that they should have collected, but that they simply did not. So, what did you hear about that? Well, you heard there was a cell phone right there on Brandon's bed. See multiple pictures of it. It's right there for everyone to see. But you heard the police didn't collect that. You heard Trooper O'Leary testify about the kinds of information that can be on a cell phone. GPS data, calls, texts, all kinds of things. You heard him explain how they go about the process of applying for a search warrant, what they have to show, that it's likely that there would be evidence related to the case. They had Brandon as their suspect. His GPS records of where he was that day, of course the judge would have signed off for that. The police could have had that. All they had to do was ask. But you heard, they didn't bother. It wasn't part of their application for a search warrant. You never heard that any officer ever asked Brandon for permission. You did hear that's another way to search for a phone, or to search a phone. In fact, that's what happened with Luis Garcia's phone. The police searched that because they had permission. They didn't ask Brandon for permission. They didn't ask for a search warrant. They didn't bother looking for the most basic thing that was right there in front of them. Well, what other ways did the police not do a thorough investigation? Did the police not obtain important evidence and information that they should have? You heard when Mark Castiglione, Brandon's father, got on the stand and testified. He said he thought Brandon had a car that day, and then he wasn't sure, and maybe it was returned earlier, and he really didn't know. Why didn't the police find out back then whether Brandon had a car available? Whether Brandon could have gone for a drive? Whether Brandon could have gone anywhere? The police did nothing to investigate where Brandon was on October 1st, 2019. Something else you didn't hear. You didn't hear any police officer tell you that they knocked on all the doors on that street, that they asked, hey, did you see anyone come or go from number 15? I mean, we're talking about basic things that you should have heard. Where was any evidence of any of that? The police did not do the most basic things in investigating this case. They didn't do it because, again, within 2 minutes, they had decided it was Brandon. He was in handcuffs in a police car. Now, I've explained to you how the police jumped to the conclusions. The government wants you to jump to that same conclusion. You heard in the government's opening statement them say how simple this case is. One bullet, one gun, one man. One man that they can't put in the house at the time of the shooting. One man that they can't say fired a gun that day. One man who had no reason to shoot his friend. What the government doesn't want you to think about is four very important words in this case. Beyond a reasonable doubt. You've heard that several times throughout the case. The government has to prove their case. Brandon doesn't have to prove anything sitting there. The government has to prove that Brandon did what they're claiming he did. They have to prove that to you beyond a reasonable doubt. I want to talk about those four words for a minute. You know, your jury service started actually before you ever saw Judge Ruoff. Started with that video that you watched first thing when you came in on jury selection day. And that video introduced you to some important legal concepts, including different levels of proof for different kinds of cases. One level of proof is called proof by preponderance of the evidence. Think of it as the scales of justice, and if they tip ever so slightly one way or another, that's proof by preponderance of the evidence. That's all it takes in some kinds of cases. But that's not the standard that you're applying here. There's another, higher standard that applies to other kinds of cases. Certain kinds of cases have a higher standard called clear and convincing evidence. If the evidence is clear, if you are convinced by it, that's enough. But again, that is not the standard that you are applying here. Here, in a criminal case, you have the highest burden, the highest standard, I should say, that our legal system has. Proof beyond a reasonable doubt. And the judge has told you, if you have a reasonable doubt, you must return a verdict of not guilty. And I want to talk to you for just a minute about why it's that way. It's that way because of our constitutions, both the New Hampshire Constitution and the US Constitution. And that standard was written into those documents. And the great scientist, statesman, founding father, Ben Franklin, said it far better than I ever could. So I'm going to read a quote from him. He said, that it is better 100 guilty persons should escape than that one innocent person should suffer, is a maxim that has been long and generally approved. That's why it's written into the constitutions, for this highest standard, proof beyond a reasonable doubt. I want to talk to you about another important moment in this case, one you may not be thinking of. On Tuesday of last week, not at jury selection, but right before the trial began, on Tuesday afternoon, each one of you stood in that box. Each one of you raised your right hand, and each one of you swore that you would follow the judge's instructions. You took that oath, and the judge has told you, if you have a reasonable doubt, you must find the defendant, Brandon, not guilty. Now, the judge will tell you that your verdict has to be unanimous, and that's certainly true. He'll also tell you that your verdict has to be your own individual vote. And I want to talk about what that means for just a moment, because you don't all have to have the same doubt. If you doubt because the police didn't get the phone, if you doubt because Brandon had no reason to kill Luis Garcia, if you doubt because the police didn't test the gunshot residue kit that they took, if you doubt for another reason, that's okay. You don't all have to have the same doubt. If each of you individually has a reasonable doubt, your individual vote is not guilty. And if each of you vote not guilty, that is what is meant by a unanimous verdict. I want to talk about some other ways that the police did not do a thorough investigation. And that, ladies and gentlemen, one of the ways is the gunshot residue that they took a kit for, that they collected, never tested. You heard about the warrant for Brandon, for his body. You saw all these pictures, a couple dozen or more, documenting everything they did, documenting what he was wearing, documenting each layer of clothes they took off, documenting his hands. You heard. The police got a warrant for all of that because they knew it could contain important evidence. You heard. They took swabbings of his hand for completing a gunshot residue kit. You heard that someone who fires a gun will have residue on their hands. The judge signed off on that warrant. The police requested that warrant. They did that for a reason. And then they didn't bother to test it. Could have shown that Brandon didn't fire a gun that day if they had just bothered to test them. But it wasn't just the gunshot residue kit from his hands that wasn't tested. It was also his clothes. All of those were collected. All of those were sent to the state lab. Those could have also been tested for gunshot residue. Again, could have shown if Brandon fired a gun. Could have proved that he did not fire a gun. The government didn't test that. You know, the only evidence you heard about actually testing for gunshot residue, that was from Dr. Duvall on Luis Garcia's hands to eliminate the possibility of suicide. I want to talk to you for a few moments about some things I think the government may try to argue to you. After I'm done talking to you here, they're going to get up, they're going to have the opportunity to talk to you too. I don't know exactly what they're going to say, but I have some guesses. And I want to talk about some things they're likely to say and why you shouldn't be persuaded by what they say. You know, at its simplest, the government wants you to believe that it must have been Brandon. He must have shot Luis Garcia and must have just stayed there and prayed for several hours. And you heard Luis didn't answer his phone after 9:30. You heard police got to the house around 2:30. So we're talking about roughly 5 hours there. That's what the government wants you to believe. And one reason that they may try to tell you that you should believe that, they may try to say, well, Brandon didn't go many places. But think about what evidence you actually heard. You heard, again, from Mark Castiglione, Brandon's father. What did Mark tell you? Mark told you, I actually don't know Brandon's routine when I'm at work. I'm not there, I don't see it, I don't know what he does during the day. He did know that Brandon sometimes went to events at churches other than New England Pentecostal, that he had multiple churches that he was involved in, went to. Did Brandon go to some event at some other church that day? Did Brandon drive the car that Mark thought he may have still had that day? Mark certainly did not say that Brandon was home. You know, the government may also try to say, well, it must have been Brandon. The doors were locked. Who else could it have been? How could anyone else have gotten inside? So let's talk about that for a moment. You heard at least one other occasion Luis Garcia let someone into the house. You heard. He had his wife Patty come over to see his painting. So you know at least one time Luis let someone in. He could have let someone else in that day. Mark said he wasn't aware of Luis ever letting anyone in. But that, again, he didn't know because he wasn't there. But you know it happened at least once. It certainly could have happened again. But here's the other thing about the doors being locked. It's not surprising if Brandon left, went somewhere, and came back, that he would lock the door behind him. He goes out, he comes back. He locks the door, he takes off his shoes, he's in his own house, and then sometime after that, he finds his friend shot, killed, and he starts praying. Government may try to convince you, well, must have been Brandon because he kept the gun locked up in his room in that file cabinet. Well, let's talk about what the evidence actually was. First of all, this is the file cabinet. You all saw it. There is the key, sitting right on top of the file cabinet. Would not have been hard for anyone to pick that up and use that. And that's if the cabinet was even locked. Because what evidence did you actually hear? Again, you heard from Brandon's father, Mark. Mark said he wasn't sure if Brandon kept that cabinet locked. Mark said he wasn't sure if Brandon was still keeping the gun in its case in that cabinet. He didn't know. What you do know is that there's another place that that gun could have been, and that is in a bag in the living room. You know it could have been there because you know guns were in that bag. The bag has a magazine. The bag has spent shell casings. Clearly, that bag was used to store or transport guns. That Glock could have easily been in that bag where anyone could get to it. The government may argue to you, well, Brandon didn't call 911. That's true. He didn't. There's no evidence of how long Brandon was there after finding Luis Garcia before the police arrived. You heard Brandon is a deeply, deeply religious man. You heard he often prays. You heard that's very common for him. You heard that when he prays, he shuts out the world. Ladies and gentlemen, it is not surprising that when he finds his friend killed, shot in the head in his own house, he comes back, finds that body. It's not surprising that for Brandon, what made the most sense was to pray. Certainly, would some other people have called 911? Yes, I think many, many would. But Brandon, what made sense to him was to pray. The fact that he did not call 911 does not make him a murderer. You know, one other thing I think the government may point to try to prove their case is fingerprints. So let's talk about those for a minute. You heard there were 2 fingerprints found on Brandon's gun. Well, again, it's his gun. He owned it. It's not surprising that his prints would be on it. And you heard the fingerprint expert, Rachel Martinez, tell you she can't say anything about the age of those prints. She can't tell you when those were left on the gun. The only thing she can say is that those prints were left sometime after the gun was manufactured. That's all. Those prints could have been there for weeks, months, years. Those prints don't tell you anything about whether Brandon fired that gun that day. The judge at the start of this case gave you some instructions. And one of the things he talked about was circumstantial evidence. And he described that. He talked about how, if it's dry outside when you go to sleep and it's wet outside when you wake up, that's circumstantial evidence that it rained overnight. It means no one saw it happen. That's what this case is, ladies and gentlemen. We have a purely circumstantial case. There's no evidence directly that Brandon shot anyone. There's some circumstances that the government wants you to believe indicate that he did. But the judge gave you one very specific, very important instruction that applies to circumstantial evidence cases. I want to get this right, so I'm reading directly from what the instruction was. And the judge told you that to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other reasonable conclusions. This means that if, from the circumstantial evidence, it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. Again, that's the judge's instruction, the instruction that you swore that you would follow. There are multiple reasonable conclusions based on the circumstantial evidence in this case. And one of those reasonable conclusions is that Brandon did not do it. It's reasonable to think that Brandon might have gone out that morning. And because of that, you must find Brandon not guilty. It's reasonable to think that maybe Garcia had someone over. And because that is reasonable, you must find Brandon not guilty. It's reasonable to think that the gun may have been left in that bag in the living room where anyone could have found it, picked it up, and used it. And because that's reasonable, you must find Brandon not guilty. Now, I want to talk to you for a few minutes about that gun. You heard about how this was tested. You heard about what information the lab had when they tested this. Now, you heard from Jill Theriault, the firearms expert. She talked to you about a training she went to about cognitive bias and how that can be unconscious, how that can, having information about a case, can unconsciously bias or taint, influence conclusions that are drawn. She said that's especially important in fingerprint cases. She talked to you about a study that she had heard about where fingerprint examiners were given 2 sets of prints to compare. And then a few weeks later, the same examiner was given the same sets of prints but given different information about the case, and how that often led them to make a different conclusion. Either that something was a match when they previously thought it wasn't, or vice versa. What did you hear from the actual fingerprint examiner here? Rachel Martinez told you she knew Brandon was a suspect. She knew the gun was found in close proximity to him. That is information she should not have had, information that influenced her conclusions. But it's not just that information that was given to her. You heard more than that. You heard how she had conversations with the lead investigator in this case, Trooper Stephen Sloper. Now, Trooper Sloper said that she was to look for evidence that would connect that gun to Brandon. And Trooper Sloper told her, if you find a connection, don't run any other tests. He specifically told her not to have those 6 swabs that were taken from the gun. 6 swabs of touch DNA. He said, don't test those. Ladies and gentlemen, the government wants you to convict Brandon without ever hearing from the lead investigator. And why didn't the government call their lead investigator? Well, you heard that too. The lead investigator, Sloper, said he was checking with the Attorney General's office and would get back and let the lab know what to test and what not to test. The very office that is prosecuting Brandon made the decisions not to test evidence that could have proven Brandon did not do it.
Objection, Your Honor. Facts not in evidence.
Well, the jury's recollection of the facts will control.
Very well. Thank you.
That's why you didn't hear from Stephen Sloper. And just to talk about that just a little bit more, you heard there were 6 swabs. 6 swabs that could have each had touch DNA taken from the grip, and there were swabs taken from the trigger itself. That evidence was not tested because prosecutors didn't want it tested because it could have hurt their case. Want to talk to you about one other very important thing in this case. Something that, quite frankly, makes absolutely no sense whatsoever. You heard testimony from Trooper O'Leary. He was the trooper in charge of actually physically collecting the evidence. You heard a lot of exhibits were labeled JGO 1, JGO 2, JGO 75, whatever the numbers were. And that JGO, those were his initials. Now, what did Trooper O'Leary tell you about the gun? Trooper O'Leary told you that he collected that gun, and he told you how many bullets were in it. And he even has it in writing. He testified to it. He has it in writing, State's Exhibit 114. I'm going to ask that you take a close look at this when you're back in the jury room, talking, deliberating about this case. Because what does this say? It says that there was 1 round in the chamber, 15 bullets in the magazine. Ladies and gentlemen, you heard from Jill Terrio. The magazine had a capacity of 15 bullets. So I guess the government wants you to believe that Brandon, sometime before 9:30, shot his friend for no reason, went to the other room, loaded 1 more bullet into the gun, then put the gun on those plastic shelves in the hallway, then went back into the room where Luis Garcia's body was, and then prayed. That makes no sense whatsoever. That is a huge reason to doubt the government's case. Why on earth would anyone do that? Brandon could have gone anywhere that morning. That is a reason to doubt. There is no physical evidence that Brandon fired a gun that day. That is a reason to doubt. Brandon had no reason to shoot his friend. That is a reason to doubt. There are many, many reasons to doubt the government's case. The government did not prove its case because it could not prove something that did not happen. Brandon Castiglione did not shoot Luis Garcia. Brandon is not guilty.